So I thought it would be really interesting for us to have a discussion about the modern slavery defence in light of the case of BRECANI. I'm going to start by talking about the two parallel systems of the national referral mechanism and the criminal justice system, which most of us practitioners will know sometimes fit uneasily together. I'm also going to summarise the relevant authorities, both leading up to BRECANI and the ones that are still good law and we can still use. And then in light of BRECANI, I'm going to answer the question of whether conclusive ground decisions are now admissible at trial. Are they still important in criminal proceedings? Are defence experts in modern slavery cases admissible? And what should we be doing as defence lawyers to maximise the prospects of success in modern slavery cases? So we have these two systems. We have the national referral mechanism, which most of you will know is a department of the Home Office, which is dealt with by the single competent authority to determine whether individuals have been a victim of modern slavery on the balance of probabilities. And then we have the criminal justice system, where individuals are charged with criminal offences, either those that fall within the Section 45 defence or those excluded by Schedule 4. And as I mentioned, they don't fit together very easily. And I just wanted to briefly talk about where the national referral mechanism came from and why we have these two systems that don't work together very well. Before BRECANI and before the Modern Slavery Act 2015, the UK did have and has international obligations to victims of modern slavery. And the relevant principles were particularly Article 26 of the Convention, which provides that member states should provide a system for the possibility of not imposing penalties on victims. And similarly, Article 8 of the Directive, which entitles member states not to prosecute or impose penalties on victims. So even before the Modern Slavery Act, we had systems in place to protect victims of modern slavery, and that was threefold. So firstly, we had relevant CPS guidelines, which indicated the capacity of a prosecutor to decline to proceed against individuals suspected of being victims of trafficking, including taking into account conclusive grounds decision. We also had the common law defence of duress where available. And then thirdly, and perhaps now controversially, we had the court's abuse of process jurisdiction, whereby the courts would intervene where it felt that the Crown had inappropriately applied its guidance and prosecuted when it shouldn't have. And so that was how victims of modern slavery who were accused of crimes were dealt with prior to the Modern Slavery Act. That all changed when Section 45 of the Modern Slavery Act was enacted, which provided a defence to those who are compelled to commit criminal offences by reason of relevant exploitation. And along came the case of R&DS of 2020. And in that case, the Court of Appeal looked again at those international obligations and said that the way that the courts had been interpreting those was not quite right. And in particular, Court of Appeal expressed that the state's positive obligation was to protect victims of trafficking, but was not expressed in terms of non-prosecution, and that they did not think that there was any basis for deriving a positive obligation not to prosecute victims of forced or compulsory labour. And they also said that prior to the 2015 Act, there was a lacuna in the law whereby the court sought to fill by expanding the notion of abuse of process, which inevitably required the judge to make relevant decisions of fact, which was no longer appropriate, and cases to which the 2015 Act applied should proceed on the basis they'll be stayed, and only if an abusive process as conventionally defined is found. So what that means is there was no longer a space where the courts were intervening to stay prosecutions that they considered was inappropriate, and it returned the usual position where the prosecution have a very wide discretion of cases to prosecute, the logic being that a jury would be able to acquit somebody for where the Section 45 defence was available. So that just sets out, so Section 45 affords a defence to those compelled to commit offences because of relevant exploitation, and Schedule 4 offences are excluded. Those are the more serious offences. For example, robbery is the typical one that we as practitioners may come across. And so even after the Modern Slavery Act, those defendants that are charged with offences in Schedule 4 have to rely on the common law defence of duress. So in terms of relevant authorities then and the interplay between the NRM process, the case of Joseph and others of 2017 held that the decision of the competent authority as to whether a person has been trafficked for the purposes of exploitation is not binding on the court, but unless there was evidence to contradict it or significant evidence that had not been considered, it's likely that the criminal court will abide by that decision. So what that meant was that the courts were no longer staying proceedings and the Crown retained a much wider discretion over who to prosecute. But when cases were getting to court, Joseph provided that unless there was evidence that significantly undermined the decision of the single competent authority, the tribunals should abide by the decision of the single competent authority. And the specific question of whether actual conclusive grounds decisions were admissible at trial was not actually dealt with in the appellate courts until DPP and M of 2020. And in that case, the High Court, the Divisional Court, found that in relation to whether the conclusive grounds decisions is expert admissible evidence, they found in favour of the defence and found that the factors relevant to trafficking or exploitation are not necessarily within the knowledge of the ordinary person, a jury member, and expert evidence on which factors are relevant may be admissible. And that case also said that in relation to the admissibility of the NRM conclusive grounds decision, the court was entitled to receive and admit those findings as evidence. The court held that the SCA decision maker did have expertise in relation to those issues, and the judge was entitled to consider the findings and assess the extent to which it was supported by evidence. And if those weren't supported by evidence, that was a matter of weight rather than admissibility. That success was quite short-lived because, of course, we then came across BRECANI. And so the headlines of that case are that the Court of Appeal said, no, DPP and M was wrongly decided. The single competent authority conclusive ground decisions are not admissible at trial. And that's because they found that SCA employs relatively junior caseworkers. They're not experts. They don't prepare their reports with criminal proceedings in mind. And so it's not expert opinion evidence. In relation to modern slavery experts, the Court of Appeal held that they may be admissible, particularly to provide context of a cultural nature. So whilst in that case, the particular report of the expert in that case wasn't admissible, that was particular to that case. And in that case, the expert, well, firstly, the Court of Appeal didn't have a full picture of his breadth of expertise. And secondly, that expert had not been provided with all the prosecution evidence, particularly some significant evidence that undermined the client's assertion that he'd been a victim of modern slavery. And finally, in relation to that, a modern slavery expert evidence will not be admissible where the expert has not been provided with all the relevant documentation, especially evidence which tends to undermine the defence case. And that's what happened in BRECANI. So what does that mean, practically speaking, for us as defence practitioners? Well, this is just my opinion, and I'd be interested to hear what other people think might be some of the implications. But I think one of the first things is that far more cases are likely to reach court. Previously, if there was a positive conclusive grounds decision and there was no evidence to contradict or undermine it, in line with Joseph, the evidential test would likely not be met in those circumstances. And so the prosecution would be dropping those cases. Now, given that the NRM decision is not admissible at trial, I think that we're going to see much more cases coming to court because they're only going to be discontinued if the public interest test is not met. And I think the second thing that is going to be a negative consequence is that victims of modern slavery, so our clients, are more likely to have to give evidence at trial. So in order to succeed in the modern slavery defence, the defence have to discharge the evidential burden, and then it's on the prosecution to prove that that doesn't apply beyond reasonable doubt. So where the conclusive grounds decisions were admissible, defendants, as was the case in DPP and M, could rely on conclusive grounds decisions to discharge the evidential burden. Now, there's going to be much more onus placed on defendants to have to give evidence in order to discharge the burden. And given that they are going to be victims of modern slavery and relevant exploitation, that's going to cause a whole host of problems, obvious ones being fear at giving evidence in an open court. So the question then is, given the ruling in BRECANI, does that render the NRM process obsolete insofar as us as criminal defence practitioners? And the short answer to that, in my opinion, is no, The case of R and HHD makes it clear that, going back to the relationship between the NRM process and the criminal justice process, the case makes clear that wherever possible, potential victims of modern slavery are to be identified before a plea is taken, and that CPS guidance requires prosecutors at the first hearing to request that a plea is not formally entered and to apply for an adjournment for further investigation into the defendant's possible status as a victim of modern slavery, and that the usual stage timetable should be altered to accommodate the NRM referral. So that case makes it clear that when criminal proceedings are brought to court before the case proceeds, there should be an NRM referral made, prosecutors should review their case and in light of the decision, and then the case should continue if it is in the public interest to proceed. And BRECANI retains, in my view, that process, and particularly at paragraph 9, where the judgment says that the CPS will ordinarily wait to know the outcome of a referral to the competent authority before deciding to charge or continue proceedings, where it suggested that the offence was committed because of relevant trafficking or coercive behaviour. So that doesn't fall away with BRECANI, and we still need to be making sure that we are getting positive conclusive grounds decision so that the Crown can review their position. And the CPS have, when reviewing cases involving potential victims of modern slavery, a 4-stage test, and I think it's relevant for us to be aware of that. So step 1 is, is there a reason to believe that the person is a victim of modern trafficking or slavery? If yes, move to the next question. Is there clear evidence of a credible common law defence of duress? If yes, they shouldn't be charged or should be discontinued on evidential grounds. And then step 3, is there clear evidence of a statutory defence under section 45 of the Modern Slavery Act? So that mirrors step 2. And in that case, the person should not be charged or the case should be discontinued on evidential grounds. So that's really where the SCA decision retains importance. And step 4, is it in the public interest to prosecute? This must be considered even when there isn't clear evidence of duress and no clear evidence of a section 45 defence. So I raise that because I move on to what we as a defence team should be doing. And so in light of BRECANI, and I think that the first important thing is to make sure that an NRM referral is made as soon as possible to an appropriate first responder. We know that with under 18s, no consent is needed for the mechanism to be engaged, but we as defence lawyers obviously need our client's consent to disclose confidential instructions and to make that referral to the first responder. With over 18s, the individual does need to provide consent for a referral to a first responder, and where that's missed, that often causes significant delays. So, for example, a client will put forward an account in interview asserting that they've been a victim of modern slavery, but there isn't specific consent for the referral to be made, and so the police are not able to make that referral until they get the signed consent to do that. So a really easy way to make sure that's done to speed up the process is to include in a prepared statement, if that's what's being put forward, that consent is given for the national referral mechanism referral to be made, if those are your instructions. And I think thought also has to be had as to which first responder. Obviously, if your client raises that they're a victim of modern slavery at the police station, then the police are bound then to make a referral. But if it happens, as it does sometimes, that your client raises it for the first time after the police station interview, and so a referral has to be made, you may want to think about contacting a charity which does have powers as a first responder as opposed to the police, because of the obvious conflict of interest that the police have. Once the referral has been made, it's really, really important to obtain the source materials and supply that directly to the SCA. And in my view, it's very important that we are then directly liaising with the SCA and not going via the first responder. What do I mean by source materials? So it will depend on the particular case, but it will likely include medical records, social services records, education records, potentially immigration records and youth offending records. And the purpose of those is to corroborate, where possible, the client's account, so that those records, objective evidence, support the evidence of your client's vulnerabilities to exploitation. And that will mean that any SCA decision is far more robust than if it is just relying on an uncorroborated account from your client. Yeah, the other thing that I think is maybe more important now in light of BRECANI is that us as defence team should be proactive in defence experts, knowing that a jury is not going to have the conclusive grounds decision, but a defence expert that does have a sufficient body of qualifications and or practical experience in modern slavery may be able to fill those boots. But it's very important that we instruct the right expert. So for example, if your case is a county lines case, it's an expert that does have particular qualifications or experience in that, or if it's a Vietnamese trafficking case in that type of exploitation. It's really, really important that the expert is supplied with all the prosecution evidence, including that which undermines the defendant's account, and the source materials, which I've spoken about earlier. And I think it's really, really important that those experts are carefully instructed. So the letter of instruction is able to guide the expert so that we're making sure that they're giving evidence that is outside the general knowledge and experience of jury members. And remember that BRECANI's made it clear, as a principle of a law anyway, but the credibility of the defendant is an issue for the jury. So it's important that the expert is adding something over and above giving an opinion on the credibility of the defendant. And that's where the source materials are important, and that's where the content, where they're able to give evidence about the practices and mores of particular trafficking organizations, in particular around recruitment, for example, grooming, debt bondage, and violence. And that way, they're giving evidence that a jury is not going to have within their ordinary knowledge. And that's also going to provide objective evidence in relation to the indicators of exploitation that will able to support a jury to assess a defendant's credibility. And where at all possible, that expert should be relying on material that supports the defendant's account, so that it's not a conclusion based just on the defendant's own account. Once we have a conclusive grounds decision that's positive, and potentially once we have a defence expert report that's helpful as well, we need to be drafting representations to the Crown using the 4-stage test, which I've referred to, supplying the source materials and the defence expert report if possible. So there needs to be more onus on making sure that that single competent authority decision is as robust as possible, and our representations to the Crown are supported by that source material. If the Crown decides that they're going to continue through with the case and the matter proceeds to trial, we can of course serve our modern slavery report if it assists. And I think it's also worth thinking about other types of reports that can help as well. So for example, where appropriate, psychiatric or psychological reports. So just as a reminder, in order for the defence under Section 45 to apply, the jury has to be sure that a reasonable person in the same situation as the person, and having the person's relevant characteristics, would have no realistic alternative to doing that act. And the relevant characteristics, as defined by Section 45(5), provides that that's age, sex, physical or mental illness or disability. Similarly, Section 1, 3 and 4 of the Modern Slavery Act provides that in determining whether a person is being held in slavery or servitude or required to perform forced or compulsory labour, regard may be had to all the circumstances, for example, the person's personal circumstances, family relationships, and mental or physical illness, and which makes the person more vulnerable than other persons. So if there is a particular psychiatric or developmental issue that you think an appropriate expert could identify, which would mean that your client is more vulnerable to exploitation than others, that should be admissible and should be pursued. And so those were my thoughts, really. And yeah, I hope you found that useful. I don't know if anyone has any questions or anything that they want to add. Yeah, it would be interesting to have a discussion about it.